Good day, friends. Today we will discuss Transfer of Property Act. It is part of real estate laws as far as IBBA syllabus is concerned. So, in which we will discuss about the transfer of property, sale of property, mortgage of property, lease of property, and what are the properties which cannot, what are the things which cannot be considered as transfer and many other things which are very important from examination point of view as well as from day-to-day work of valuers of real estate. So first thing we will discuss it about the transfer of property act. What is transfer of property act basically? So it is one of the most important act relating to transfer of real property. This act deals with the transfer of real property. It was promulgated in on 1st July 1882 and it contains chapter 1 to chapter 8 with 187 sections, and then this act was revised in 1980 1929 to accommodate the conflicting court decisions which were taken during 1882 to 1929. So it was known as Property Amendment Act 1929. It was further amended and during 2002 and is now which is now known as Transfer of Property Act Amendment Act 2002, and the act is in conformity with the English principles of law of real estate, law of real property. The act has remained on the statute books of for more than a century, and its provisions have received exhaustive judicial interpretations. The act has yet not lost its primitive and original vigor and continue to throw challenges after challenges to the courts as well as to the lawyers. So the act is applicable through provisions to suit the local condition. The country and the states have been given limited powers to amend some of its provisions to suit the local conditions. So, what is the mean of transfer? Transfer means transfer of movable and immovable property. So, it how it can take place? It can take place by two methods. One is by act of parties, and other is by operation of law. So, as far as act of parties is concerned, it is through testamentary and it may be through inter vivo. So, the word operation of law, it means by transfer by succession, forfeiture, insolvency, execution of decree, etc. So, as far as transfer of law is operation by operation of law, so it is the term which is generally given to the transfer by succession, by forfeiture, by insolvency, liquidation, or execution of decree, etc. So, such transfers are enrolled by relevant acts, and the Transfer of Property Act does not apply to such transfers. And then the other thing, testamentary. So, what is testamentary basically? So, testamentary transfer means transfer through a written document providing for the disposition of one's personal property after death. The document is known as a will and is used chiefly in the phrase last will. It means if the transfer is done through will, so it is called testamentary transfers. So the contents of the Transfer of Property Act also do not apply to such transfers by operation of law such as in insolvency or liquidation processes. So the Transfer of Property Act deals with inter vivos or voluntary transfers between living persons. So such modes of transfers includes sales, mortgage, lease, exchanges, gifts, and actionable claims. So these are the main things which deals with transfer of property act, which is sales, mortgages, leases, exchanges, gifts, and actionable claims in this respect. So the Transfer of Property Act does not recognize the following two transfers. See which of the transfers are not considered are recognized by Transfer of Property Act. First one is family arrangement. So the agreement in the form of family arrangement is made between the members of the same family for the purpose of well-being and harmony of the family. The disputes among the family members are thus avoided and the honor of the family is safeguarded. So a family arrangement may either be oral or in writing in a memorandum. So the terms of the oral form of family agreement arrangement may be subsequently recorded. So if some family arrangement is done, then it is will not be considered as transfer of property. Then if the partition is done in this type of transfer, each owner gets a specific property in lieu of his rights in all the joint properties. So, thus each co-owner renounces his rights in favor of other co-owners for the rights he is getting under partition. So, it is thus a reunification of mutual rights and does not involve any transfer by one co-share of his interest in the parties to the other. So, it will not be considered as a transfer of property. So next thing is what is immovable property basically. So in this act, the definition of immovable property is not given, but the section 3 of the act provides some exclusions as follows. So immovable property does not include standing timber, growing crops, and grass. So these things are not included in the immovable property. So what are the examples of immovable property? First one is land and building, then right to collect rent of immovable property, a right to pay the interest of mortgagee, right to collect lac from trees, right to fishery, and things attached to the earth. All these things comes under the heading of immovable property. So the things which are not covered as immovable property are right to worship, government promissory notes, right to recover maintenance allowance, decree of area of rent, machinery which is not permanently attached to the earth. It will not be considered as immovable property. Then, what is transfer of property? What is its definitions? So, the term transfer of property is defined as an act by which a living person, so we will discuss who is a living person, so by which a living person conveys property either in present or in future to one or more other living persons, so or to himself and one or more other living person. So, who are living persons? The living persons include a company or association or body of individuals, whether incorporated or not. But at the same time, it is also provided that nothing in this act shall affect any law for the time being in force relating to the transfer of property by such companies or associations. So, this is what is transfer of property. What are the requirements of a valid transfer? First thing, as far as the provisions of the Transfer of Property Act, the property transferor and transferees must all be in existence. First thing is, and the condition that the property must be in existing does not mean that there can be no arrangement for the transfer of a future property. The term future property refers to an interest in which the person hopes to take under a will or future royalties, future book debt, proceeds of any future sales of specific property, damages to be recovered in pending litigation, etc. So these things may also be considered as a property. So first thing is the property transferor and transferee must be in existence, but certain future properties can also be considered under this, may be considered as a valid transfer. Second thing, transferor and transferee should not be identical in all respects. The Act requires that each should have a separate legal status. The third thing, property of any kind may be transferred except otherwise provided by this Act or by any other law for the time being in force. Some of the illustrations of the property which cannot be transferred are as follows. Easement apart from the dominant heritage. Mere right to sue cannot be transferred. He cannot transfer the property if he has mere right to sue. Then restricted interest in the property to be personally enjoyed by the owner himself. Then stipend allowed to the military and other pensioners. Unlawful subject matter as per Indian Contract Act. So it is these things cannot be transferred. So it is essential that a person who intends to transfer the property must be competent to do so. So every person competent to contract is entitled property or authorized to dispose of transferable property. And if it is not his own, he is competent to transfer such property either wholly or absolutely or conditionally in circumstances to the extent and in the manner allowed and prescribed by any law for the time being in force. For instance, a partner has no employed authority to transfer immovable property belonging to the firm. But in the case of trustees or directors also is necessary for them to comply with the relevant provisions of the law. A minor also is not competent to transfer the property. And next, a transferee must be legally competent to hold the transfer and should not be disqualified to receive the transfer. These are the conditions under which the transfer of property can be done. And next is the necessary formalities like registration, attestation, etc. should be fulfilled. A transfer of property may be made without writing in every case in which writing is not expressly required by law. A right to recover share of immovable property may be relinquished orally and without instrument in writing. So this can be done orally. The test to determine whether a transaction to be made without writing is to see if it is expressly required to be in writing, and if it is not, it may be made without any writing. The next is what is contingent contract. Contingent contract whereon transfer of property and interest therein is created in favor of a person to take effect only on the happening of a special uncertain event. See here, an interest therein is created in favor of a person that can take place only on the happening of a specific uncertain event, or if a specified uncertain event shall not happen. Either certain event should happen or certain event should not happen. Such person thereby acquires a contingent contract in the property. Such event in the former case becomes a vested interest on the happening of the event, and in the later case when the happening of the event becomes impossible. See here, the distinction, there are two things. One is vested interest and other is contingent interest. What is the difference between vested interest and contingent interest should be noted. An estate or interest is vested when there is an immediate right or present right of future enjoyment. Then we call it that it is vested interest. And and an estate or interest is contingent when the right of enjoyment is to acquire on the event which is dubious or uncertain. Some of the illustration of contingent interest are as follows. A transfer to a person to take upon his attaining a particular age gives him only a contingent interest till he attains that age. And if a person dies before the contingency disappears, before the vesting occurs, the heirs of such a person do not get the benefit of gift. So let us suppose a gift has been given to a person, but it is conditioned that he will get this gift at a certain age, but he dies. Then means before the vesting occurs, then his successors cannot get the benefits of this gift. Then let us suppose person A transfers property to person B for life, and after his death, two persons C and D equally to be divided between them are to the survivor of them. But person C dies during the lifetime of person B. The person D survives the person B. At the B's death, the property passes only to the person D. See here in this case that A was to give the property to the B for the life and after his death to C and D. But C dies during the lifetime of B, and but only D survives the person B. So after B's death, property will be given to D only. Then next is conditional transfer. The transfer may be purely absolute or may be conditional. The interest created by conditional transfer fails when the condition is impossible to fill or is of such a nature that if permitted it would defeat the provision of law or is fraudulent or involves or implies an injury to the person or property of another or the court regards it as immoral or opposed to the public policy. The conditional transfer may be precedent nature or subsequent. For condition precedent, the terms of transfer of property imposes conditions to be fulfilled by a person before the person can take the interest in the property. The rule has been laid out that it would be sufficient if the property condition has been fulfilled substantially. For condition subsequent, the terms of transfer of property lay down that condition to be satisfied afterward. Some of the illustrations of conditional transfer are person A transfers 5 lakh to his niece C. If she will desert her husband, so transfer is void. So it can this such type of transfer is void. Or a land was given to a religious institution for the purpose of building an ashram. The institution ceased to exist before it could build an ashram. So it was held that the gift failed. Let us suppose the person A transfers 50,000 to person B on the condition that he shall marry with the consent of three persons C, D, and E. But the person A himself dies. The person B marries with the consent of persons of C and D. The person has deemed to fulfill his condition. And fourth, the person A transfer a farm to person B on the condition that B has to go to England within years after the date of transfer. Otherwise, his interest in the farm shall cease. The person does not go to England within the terms prescribed. Hence, his interest in the farm given by B ceases and comes to an end. These are certain conditional transfers which may be valid or which may not be valid. These examples have been given which will clear your doubt. Then sale of immovable properties. The sale of immovable property is done under section 54, in which the ownership in exchange for a price paid or promised or partly paid or partly promised. So a sale is a transfer of ownership in exchange for a price paid or promised or partly paid and partly promised. So transfer in case of tangible immovable property can be made only by a registered instrument. So it must be remembered that price in the form of money is an essential element in the sale. If consideration is not money, it may be anything but cannot be a sale. See this. So what is sale of immovable property? It is defined under section 54. These are the conditions, and this is a definition that a sale is a transfer of ownership in exchange for a price paid or promised or partly paid or promised. And similar to the conditions of contract, the consideration must be there. So rights and liabilities of the seller. Following are the rights and liabilities of seller. He has to answer all the questions in relation to the property to the buyer, and he has the right to collect rents and profits from the property till the property transferred to the buyer. He has to disclose to the buyer any material defect in the property. He has to execute a proper conveyance of the property. He has to pay all the taxes occurred in respect of the property up to the date of sale. He has to produce all the documents of title for inspection. He has to take reasonable care of the property between the date of contract of sale and the delivery of the property, etc. So these are the rights and liabilities of the seller as far as transfer of property act is concerned. And then these are the rights and liabilities of the buyer. First thing, he has to bear the loss arising from the destruction, injury, or decrease in value of the property not caused by the seller after the ownership of the property has been passed to him. And then he has to disclose to the owner any fact as to nature or extent of the seller's interest in the property of which he is aware, and he has right to get the benefit of any improvement or increase in the value of the property of the ownership of the property has been passed to him. He has to pay all the public charges and rent which may become payable in respect of the property after it has been passed to the buyer, and he has to pay the purchase money to the seller, etc. Then mortgage of the property. So there are six types of mortgages recognized by Transfer of Property Act. This is under section 58 of the Transfer of Property Act. First one is simple mortgage. So a simple mortgage consists of personal obligation to pay the rights of the mortgagee to cause the property to be sold in default of payment. So the right of sale of mortgage property, however, cannot be exercised without the intervention of the court. See here, even if there is default of payment, it can be done with the intervention of the court in case of simple mortgage. Then mortgage by conditional sale, second type of mortgage. So in this type of mortgage, there is no personal convenience to pay, but the following three alternative conditions are embedded in deed: that on the default of payment, the seller would become absolute, that on payment, the sale would be void, and that on such payment, the buyer shall transfer the property to the seller and possession of the property. Then usurpatory mortgage. So in this type of mortgage, the mortgager delivers the property to the mortgagee and authorizes him to retain such possession until payment for the mortgage money and to release the rents and profits from the property and their appropriation towards interest or mortgage money. There is no personal liability on the mortgager, and there is also no time limit fixed for that. There can be no sale of such property to recover mortgage money. Next is English mortgage. In this type of mortgage, mortgager binds himself to mortgage money on a certain date and transfer the mortgaged property part to the mortgagee. If payment is made in time, there is no obligation on the part of the mortgagee or to transfer the property. Then mortgage by deposit of title deed, which is generally done in case of banking, okay, industry. So this type of mortgage is also known as equitable mortgage. The mortgager deposits the title of the property with the mortgagee with an intent to create a security for the mortgage money. So it is not necessary to deposit all the documents of the title to the property or show the document deposited indicated a good title. Then anomalous mortgage. Any mortgage which does not fall under any of the above five categories is known as anomalous mortgage. Then next is lease of immovable property. So basically we have already studied this part of in income approach method. So we will just go through the section under 5 under which the lease of the property has to be registered. So a lease, we already know what is lease. A lease of immovable property is defined as a transfer of right to enjoy such property made for a certain type, express or implied, or in perpetuity in consideration for a price paid or promised, or of money, a share of crops, service, or anything of value to be rendered periodically or on specified occasions to transferor by the transferee who accept the transfer on such terms. So here the transferor is called lessor in case of lease. The transferor is called lessor and the transferee is called lessee. And the price paid is called premium, and the money, share, or services or other thing to be so rendered is called rent. And so these four things you should be clear in your mind. The lease for agricultural purposes are not covered in the provisions of transfer of property. Actually, you have to remember that lease under for agricultural purposes is not covered under Transfer of Property Act except the notification made by the state government in this respect. The reason for exempting agricultural leases is understood to keep the settled uses which generally regulate the rights of the parties and are embedded in local acts. Next is exchanges. It is done under section 118 to 121 where two persons mutually transfer ownership of one thing for the ownership of another. Neither thing or both things being money only, the transaction is called an exchange. The exchange postulates an actual transfer of ownership. It is distinct from sale, despite the common feature that there is mutual transfer of ownership of one thing for the ownership of another. If the consideration is the price of property transfer, it is sales. But if the property not being the price, it is exchange. So see the difference here. If the consideration is the price for the property transfer, then it will be called sale. But if it is property, not property for property, but not the price, then it is called an exchange. So in order to constitute an exchange, there should be mutual transfer of ownership of property. Hence, if transfer does not constitute a transfer of property at all, it cannot be called an exchange. Thus, the family arrangements, partitions, transfer in order under a compromise decree, etc., are not treated as exchanges. It is also necessary that exchange that both the parties must be owners of their respective properties. The next is gifts. So it is done under section 122 to 128. The term gift is defined as transfer of certain existing movable or immovable property made voluntarily without consideration. First thing is it should be made voluntarily, and other thing it should be without consideration by one person. Though the person who gave the gift is called donor, and the person who received the gift is called donee, and accepted by or on behalf of the donee. It must be there. Their acceptance should be there. So why it should be there, we will discuss in the coming slides. The acceptance of gift must be made during the lifetime of the donors. These are conditions, and while he is still capable of giving the gift. These are the two conditions. First thing is the acceptance must be during the lifetime of the donor, and he should be capable of giving the gift. If the donee dies before the acceptance, the gift is void. For onerous or troublesome or burdensome gift, the provisions is as follows. If the gift is in the form of single transfer of same to the same person of several things, then the donee cannot take nothing by gift unless he accept it fully. See here, if there is several things are gifted, so he has to accept it in totality. He cannot say that he will be accepting one or two things and not accepting other things. He have to accept it fully. And second, if the gift is in the form of two or more separate or independent transfers to the same persons of several things, then the donee is at liability to accept them and refuse the other. So although the former may be beneficial and the later onerous. So if one person gives other person a number of things in a single donation, so he has to accept it in totality. But if is giving several things in not in a single donation, he can accept or reject one or two out of these three, for example. So next is universal donee. Is a legal representative of the donor. So universal donee is a legal representative of the donor, where a gift consists of donor's whole property. The universal donor is personally liable for all the debts due by and liabilities of the donor at the time of gift. To the extent the property comprised therein, it is evident that there is no compulsion on the universal donor to accept a gift. But if the gift is burdensome, the universal donor is free to reject it. But once he accepts the entire assets of the donor, it is only just and equitable that he should also share the liabilities of the donor. Such a rule of universal donor is based on the grounds of natural justice, morality, and public policy. Means, let us suppose that a person gives his whole property, Mr. A gives his whole property to Mr. B, and Mr. B accept it. But if he has accepted, then the liability, debts, etc., over his property has to be paid by Mr. B if he has accepted. But it is his right. He can refuse to accept the property under such condition that I will not going to pay the debts. I am not accepting this gift. But if he has accepted, then he has to pay the liabilities of the properties also. So such a rule of a universal donor is based on the grounds of natural justice, morality, and public policy. So next thing which is under Transfer of Property Act, actionable claims. So what is an actual actionable claims? Means a claims to any debt other than a debt secured by mortgage or immovable property or hypothecation or pledge of immovable property, or to any beneficial interest in the movable property not in possession either actual or constructive of the claimant, which the civil courts recognize as affording grounds for relief, whether such debt or beneficial interest be existent, occurring, conditional, or contingent. So, the transfer of an actionable claim, whether with or without consideration, shall be effected by an execution or an instrument in writing signed by the transferor or his duly authorized agent. The transferee of an actionable claim can then sue or institute proceedings for the same in his own name. To protect the principle of public policy, the Act has imposed disabilities on certain persons, and thus no judge, legal practitioner, or officer connected with any court of justice shall buy or traffic in or stipulate for or agree to receive any share or interest in any actionable claim. So this is all about Transfer of Property Act. Please like, share, and subscribe our YouTube channel www.youtube.com values club at the rate values club 07 for more educational videos on valuation and other related videos. Of course, all these videos are free of cost. And if you have any suggestion, please comment in the comment box. Your suggestions are always welcome. Thank you and have a nice day. Thank you very much.